Evening, it was an extraordinary scene, a blockade that ground parts of the country to a halt and sent tensions between native protesters and police into overdrive. But more and more, it looks like last summer's Mohawk barricade near Kingston, Ontario, was remarkable for what was happening behind the scenes. CBC News has learned that police were wiretapping even more people than Mohawk leader Sean Brandt. As Ron Charles explains, it's a discovery that raises questions about what police can do without anyone's knowledge.
He is facing criminal charges for a native blockade last summer. But today, Sean Brandt is charging that Ontario's provincial police illegally wiretapped phones during the protest. Phones belonging to him and to 3 other people from his Mohawk community, including his brother, a practicing lawyer.
I don't believe, given his reputation and his integrity, that there would be a judge in that area that would have signed a warrant to authorize a tap on his phone. The last time that
in fact, no judge did, not for any of the wiretaps. The OPP used a criminal code provision that allows for emergency wiretaps in exceptional circumstances without a judge's permission. The phones of Mario Baptiste and his son were also tapped, even though the one-time Mohawk activist says he wasn't anywhere near the blockade.
Who's ever responsible for it should be held seriously accountable for it. You know, if they'll do it to me, they'll do it to anybody they want, whenever they want.
When police go to a judge for permission to tap someone's phone, they also have to inform the government and eventually the suspect that they've been eavesdropping. Not so with the emergency provision. No one has to be informed that the police have been listening in. That's one reason a BC Supreme Court judge struck down the provision earlier this year. In his ruling, Justice Barry Davies said the fact that police never have to reveal the emergency taps removes an important safeguard to the potential abuse of power. For now, police in Canada can continue to use the provision because the judge stayed his ruling for 18 months.
Meeting the requirements.
This law professor says with no reporting or tracking, no one knows how often police use the emergency provision.
That the police can resort to it in circumstances that they claim are exceptional, which aren't in fact, and there's no mechanism in place to police that. That's what's problematic.
Ontario Provincial Police Commissioner Julian Fantino was not available for comment today, but in testimony at Brandt's preliminary inquiry, he denied any knowledge of how the wiretaps were obtained. He has also defended his overall conduct during the standoff, saying the positive outcome of the incident speaks for itself. Ron Charles, CBC News, Toronto.